Judge, we were previously here on May 18th. The court had put down an order. There were several motions on the court's docket that day. I'm not sure if the court recalls.
I do recall.
The court had put down an order saying the court would confer with Judge Wallace to see about taking over this case. I believe a motion prior to Mr. Thomas retaining me, and now Ms. Thomas has gotten new counsel, but there was a motion that occurred. I believe Judge Wallace heard it on temporary support. We had filed on behalf of Mr. Thomas a request for the court to review that, as he was not present when that was established. Beyond that, the court had ordered the parties comply and get the DNA testing done. That has been done. Mr. Thomas is indeed the father of these two minor children born during the pendency of the marriage. We also, the court had entered an order stating that this court had jurisdiction over those minor children in regard to the emergency motion for temporary custody that Mr. Thomas had filed due to the adoption with the newly born child. And I think the court ultimately left it at the court would confer with Chancellor Wallace about taking this matter over.
I did confer with Chancellor Wallace, and he has no problem with me hearing this case and doing whatever needs to be done. So.
Understood. And so I think where we're at, Judge, we have agreed, Mr. Kirby is now representing Mrs. Thomas. I believe he filed a notice of appearance in this matter last week. We have agreed I will give Mr. Kirby some time to get up to speed on the temporary support issues. I think we do have to address today the immediate motion, the emergency motion for return of the minor children. Mr. Kirby filed a response to that on Friday, citing the UCC JEA and how this court needed to reconsider its previous ruling on it having jurisdiction over that minor child. I don't know if the court wants to hear testimony on that today or just argument.
I'll hear whatever you want to hear. So.
And I really think factually it's undisputed. The child was born in West Virginia. There was an order of protection entered by the General Sessions Court here in Dixon that included one of the minor children on it. The baby Thomas had not yet been born. Mother relocated pursuant to an agreed order. That order of protection was appealed. The parties reserved that for a final hearing. The new minor child was born in West Virginia. Not entirely certain on the facts. The child at some point went from West Virginia, I believe the day she was born, and relocated to Colorado with pre-adoptive parents. I know it's mother's position that this court does not have jurisdiction under the UCC JEA to make an initial custody determination. However, father would aver that under 36-6216A2, this court does have jurisdiction to make that initial custody determination. I'm sure the court's familiar. It's kind of our argument that there is no home state of this child. Home state is defined under the UCC JEA as a child that's living with a parent or a person acting as a parent. If the child is under the age of 6 months, it's the state in which the child's lived from birth with any of the persons mentioned. So that would be a parent or a person acting as a parent. Child's in Colorado, not with a parent and not with a person acting as a parent. The person acting as a parent is defined under that statute. It's our contention that the pre-adoptive parents in Colorado are not persons acting as a parent. So it's our contention Colorado is not the home state. That leaves West Virginia. There's no actions pending in West Virginia to our knowledge that we've been notified of. Also, mother under the UCC JEA has a continuing duty to supplement to this court in a divorce proceeding under the UCC JEA if anything is to change during the pendency. If the child is to relocate, knows of any proceeding that could affect the current proceeding, none of that was complied with here, Judge. We would aver mother has unclean hands. She's done this to try to gain an advantage in this divorce proceeding. I know that's more of an argument for father to make in Colorado if that court tries to exercise jurisdiction over this minor child. But we would assert under 36-6216, A1 is not applicable, and therefore the court would have to go to A2, and we believe the court can exercise jurisdiction under A2 as a court of another state. Neither Colorado nor West Virginia has jurisdiction in this matter with respect to making the initial child custody determination. With that being said, if the court does conclude today that the court has jurisdiction. Mother has filed documents in the Colorado court saying she surrenders her rights to this child. Mr. Thomas is the biological father. He wants to be the father. He's got stuff set up at his house to be the father. He couldn't communicate with Miss Thomas because of the order of protection. She relocated out of state. He couldn't be there during the birth of this child. That wasn't his own request. He was prevented by law from doing that. So it's not like we have a person that's just intentionally not being present in this child's life. He was prohibited by an order that he could not be there. So we are requesting that if the court determines that it has jurisdiction, that the court issue an order, a temporary emergency order, transferring custody of baby girl Thomas, who's located in Colorado, to Mr. Thomas, which also brings significant concerns to the party's other minor child that is in mom's care, custody, and control. She relocated and he's had no contact. When he finds out, and I think they're going to say there was some knowledge about him having knowledge of an adoption proceeding, he was not, they didn't communicate, there was an order of protection. He has serious concerns about this other child that's in mother's care. When you take one child and put her up for adoption and you surrender your rights, that he doesn't know where this other child's located. He doesn't know what's going on with this child. So he has significant concerns about the mother's fitness to care for the other child as well. So we're asking the court to, if the court determines it has jurisdiction in this matter, to make the initial custody determination to award him temporary immediate parenting time with these two minor children.
All right, you and Mr. Thomas have a seat over here at the table. Let me hear from Mr. Kirby, and then we'll start.
Morning, Your Honor.
Good morning.
I'm coming into this court late in terms of this case, so I apologize about that, but I got hired and filed an agreed order for substitution late last week and filed a response to this motion. I was not present at what happened previously. I can't speak on that. But what I can say is this, that there was a statement made by opposing counsel in terms of Mr. Thomas wants to be a part of these children's lives. I think that would have been something that should have been considered prior to him domestically assaulting, sexually abusing, emotionally abusing the mother of these children at this point, to which he's not only pled guilty to the actual action, he's also pled guilty to a violation of the order of protection as well, and that's here. This is not something that is new for Mr. Thomas, as he has a background of domestic violence. He's actually currently pending a charge, I believe, in South Carolina for domestic violence against another individual. The allegations of which are that he threw items to include broken glass and attempted to strangle that individual. That is still currently pending. He is not a safe individual to have around. And he has made that clear. He has a history of drug use. We would say that he probably still is considering and taking those drugs. Obviously, with less than a week of me being on the case, I haven't been able to get everything together that needs to be together. I'm still getting the file together from opposing counsel and previous counsel to come here before the court today. What we have here, though, is a question of jurisdiction, where it is undenied that this child has never stepped foot in Tennessee, was not born in Tennessee.
Let me interrupt you and ask this question. Are you aware how long this case has been pending?
Correct, yes.
It was filed October the 3rd of 2025, and your client has made an appearance and has filed pleadings in this court, submitted to this court's jurisdiction. Would you agree?
Not as it relates to this child, no.
A DNA test proved he was the father, but by then, his newborn had already been placed with pre-adoptive parents in another state. He rushed to court demanding his daughter back, only for the mother's lawyer to unleash shocking abuse allegations. Now, a judge must decide, does the father get his child back? Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.
Well, when you say not as it relates to this child, so you're saying that a person can have a divorce case pending in this court that concerns the custody of one of their children, and that if she flees the state and goes to another state, has a child out of wedlock, or has the child there in that state, that somehow that robs this court of jurisdiction over the second child?
I don't think it robs the court of anything because I don't think the court ever had anything to be robbed of as it relates to the second child. She didn't flee the state. She was, by agreed order, allowed to leave the state because of the physical issues that had happened within the party's marriage at that point. Mr. Thomas doesn't know her address because that address is protected based on the physical issues that had happened within the party's marriage at this point. So she didn't flee in any way whatsoever.
Maybe that was a poor choice of words.
No,
on my
and I
part, so.
understand, Your Honor. As far as the jurisdiction of what we're looking here, I have no qualms that this court has personal jurisdiction over these two individuals as it relates to the divorce. I have no qualms that this court has subject matter jurisdiction as it relates to the divorce of these two parties. I have no qualms that this court has subject matter jurisdiction as it relates to the party's oldest child. I believe the name is Scarlett, if I remember correctly. I do have qualms that this court has jurisdiction related to the youngest child. And the reason being for that is that home state is defined as if a child is less than 6 months old, home state is defined as the state in which the child is born. West Virginia is the state in which the child is born. We don't get to A2, as was being argued by Mr. Bellamy, because we don't get past A1. West Virginia was the home state. We cannot confer subject matter jurisdiction to this court. These parties cannot agree to subject matter jurisdiction to this court. We have had many cases previously where we have a divorce going on in one state and we have to bifurcate it to the extent that custody has to be decided by a different state. I've had issues where custody is being decided by one state and it's bifurcated where child support is going to be decided by a different state. We have those issues pop up continuously, and this would be yet another issue of that point. When there is a question of UCCJA, I believe the next step, I think what the court is required to do, is to communicate with the judge of that other jurisdiction. We know what that other jurisdiction is. My understanding after talking to my client is that there was an ICPC between West Virginia and Colorado for the purposes of the adoption. I do not have a certified copy or a copy of that to hand to the court today. Again, I apologize. I'm coming into this late. I know that. I didn't file a motion to continue this because I know the court wanted to hear about this part of it. But I think Colorado has the open adoption right now. Mr. Thomas has representation in Colorado for that adoption at this point. He has every right to litigate that adoption in Colorado. And the adoption, as we all understand, would also be covered by the UCCJA as well. Child custody includes the idea of adoption litigation. I think it is most appropriate and the best next step, and I think what is actually considered and required by the UCCJA for this court to have an in-camera conference with the court that is doing the adoption litigation in Colorado and then discuss it from there. I don't think this court has the jurisdiction to take anything away from Colorado. I understand where the court's coming from. I do. But I don't think this court has the power to say, Colorado judge, you've accepted this. You've accepted these documents. You've accepted this litigation. But me sitting here in Tennessee, I'm going to take that away from you. Whatever happens after y'all's in-camera review, we can deal with that afterwards. But right now, I think that is the next step. As far as the argument of this child needs to be returned, or shouldn't say returned, this child needs to be given for the first time ever to Mr. Thomas, there's a couple things I would say about that. One, my client hasn't abandoned this child in the sense of just not having any communications with what's going on or not caring for the welfare of this child. In fact, she is sending breast milk to this child on a regular basis to the presumptive adoptive parents in Colorado.
Why is she giving this child up for adoption?
This was a child, this would have been 5 children in her home at this point. She has 4 other children, including the oldest child that's at issue here. This child there was some postpartum issues. This was something that was discussed, my client would say, prior to the order of protection being in place between these parties. It would be my client's statement that the father said on many occasions, or at least one occasion, I should say, that he would sign the adoption paperwork for that child if she signed the divorce paperwork. That's not where we're at, and that's not what's going on. say that they never had any idea of adoption, that's false. They had talked about the adoption as it relates to this child. Was he given specific notice? I can't say that. I wasn't on this case when it happened. I'm going to defer to Mr. Bellamy saying that he got specific notice only when he got served. That's the best explanation I have as far as that's concerned, Your Honor, where they've had communications with it. This was a plan from the beginning. These were pre-adoptive parents that in Colorado that had been a part of this pregnancy throughout, is my understanding of this. This was always the plan, is my understanding. As far as taking that child and giving it to Mr. Thomas for the first time, a couple things that I want to say about that. One, we have an older child that's not even seeing this father right now because of all the protective issues that we have in place. Two, we still have pending criminal charges. Three, we still have an order of protection that's in place right now. Four, when we get to this point of looking at that, the consent that was there and submitted by my client, it actually states in there that were that adoption to not go through for some reason, whatever that reason might be, whether it's jurisdictional or otherwise, that child will return to my client's care and custody. That's what the consent states. If anything, if something happens with that adoption, the point emphasis would be that that child returns to my client based under the essential contract law that has been entered into between my client and these adoptive parents. The other part of this that I would say is that there's nothing going on with Scarlett. To say that there's an adoption proceeding there, that means that she's doing something with this older child is disingenuous at best. There's nothing that needs to be said about other litigation with Scarlett because there is none. If the court wants us to have a specific order stating that nothing will be done with that child, I have no objection to it because nothing's going to be done with that child. That child is with my client. That child's well taken care of. That child does not really even know father at this point based on everything that's been happening with this proceeding as far as the order of protection and protective orders that have been in place. Thank you, Your Honor.
This court is of the opinion that there is a fundamental difference in this case than in the normal UCJE Uniform Child Custody and Visitation Act cases. Number one, this case was filed in this court on October 3rd of 2025, and that was the complaint that was filed, so jurisdiction was invoked in this court. The court then conducted a hearing in front of Judge Larry Wallace in February of 2026 and entered an order regarding the custody, support, and so forth, which was again exercising the jurisdiction that this court had over these parties and the child that was born at that time. So what the argument that the defendant in this case, or actually it's the plaintiff in this case, actually the plaintiff was filed, a complaint was filed by Michael Thomas. The order that was drafted shows Rachel Thomas as the plaintiff, but I think that is incorrect. That may have been with the order of protection situation. In any event, the court entered an order that controlled the parties and ordered certain testing to be done for DNA. There was, I think there was an order for support and so forth that was entered in this court. So Ms. Thomas invoked the jurisdiction of this court to her benefit by obtaining an order of this court. Now she seeks to say that this court doesn't have jurisdiction over the child that was born simply because she relocated to another state.
DNA proved he was the father, but the courtroom was stunned to learn his newborn had already been placed with pre-adoptive parents in another state. The father demanded custody, claiming he was denied the chance to raise his child, while the mother argued the adoption had been planned all along. The judge then faced one critical question: who has the legal right to the baby? Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.
I am of the opinion that that does not prevent this court from having the opportunity to, or having jurisdiction to decide the custody of both children. To rule otherwise would encourage parties who are dissatisfied with the court's ruling on a custody case and they have a pregnancy involved, and they simply move to another state and thereby make the argument that this court is robbed of jurisdiction because that child was born in another state. I understand that where children are, the Uniform Act provides certain protections that if a child is living in another state and that state is asserted jurisdiction. But this court has already asserted jurisdiction over the parties and their older child. And this court, part of what this court will have to do, whether it's me or another judge, is to make a determination as to the custody of that oldest child. Part of that factor will be the behavior of the parents, all of those statutory factors, and the factor of whether or not these siblings are together or apart, and what was her reason in placing this child up for adoption and so forth. So I'm of the opinion that the jurisdiction of this court extends to this young child that was just born, and that the Uniform Child Custody and Jurisdiction and Enforcement Act does not prevent this court from having jurisdiction over that child simply because Ms. Thomas moved to the state of wherever she's located in West Virginia or wherever it is, and then placed the child up for adoption in Colorado. Colorado's only jurisdiction over the child is because the child was brought into that state for the purposes of an adoption. And if the adoption is not valid because there's been no surrender of that child by the father, then in my opinion, that court does not have proper jurisdiction under the Uniform Act either to do it. I think this court is the only court that logically would have the right to make those decisions. So I am of the opinion that this court, and do hereby hold that this court continues to have jurisdiction over the parties and the parties' minor children. The Colorado court obviously may take a different view, and there may be an extensive litigation involved in that. However, Mr. Thomas's request that this child be surrendered to him in view of all of the allegations that have occurred in this case is not something that the court will automatically take it upon myself to simply say, well, he's going to get custody of this child. He doesn't know the child, has never had any contact with the child, and the older child, there are certain protections in place because of the allegations of domestic assault and domestic violence. So it's this court's opinion, at least, that it is not an automatic thing that I can return this child to Mr. Thomas. The Colorado court's going to have to rule on whether or not they have jurisdiction. It'll be litigated there. I'm assuming that Ms. Thomas may choose to make an interlocutory appeal on my ruling regarding jurisdiction. If that's what she chooses to do, I would authorize that because I think it's a very unique legal question. In the meantime, Mr. Thomas's rights are protected against this court, at least under this court's order, from any surrender or any termination of his rights for failure to have a relationship with the child because he's attempting to do so, and this court is of the opinion it would not constitute abandonment that would result in a termination. Then that brings us to what are we able to do at this point other than my ruling that we have jurisdiction. I think it's going to require, before I can do anything about that child, we need to see what Colorado is going to do regarding their I don't think West Virginia is really the issue. Child's not there. Being born there doesn't mean they have jurisdiction. So with that, Mr. Bellamy, do you have anything you wish to add about today other than the fact that I've reaffirmed my ruling? And we set this hearing to determine what the DNA tests were going to be. DNA shows he is the biological father. I'm therefore ruling that we do have jurisdiction over this child. If the defense wishes to seek an interlocutory appeal to a court of appeals for their interpretation, and I'm willing to do so, do you want to put on the record the circumstances of this so that there is a record made to take to the court of appeals? That would be the only thing I would offer.
Judge, just a few things if I could add briefly. The order of protection in this case Is the court saying that the order of protection extends to the newborn minor child?
I'm not saying that the order of protection extends to the newborn minor child. It extends to those people who were listed on the order of protection. The order of protection lists the mother and a stepdaughter, a stepson, and Scarlett Thomas, who is the child of these parties. It does not mention this unborn child. It was issued back in September of 2025, and therefore the child obviously she was pregnant with the child, and it could have mentioned that, but it did not. So I'm of the opinion it does not apply to that child. But asking me to order that the child be surrendered to Mr. Thomas in view of the allegations is what I'm simply saying. I'm not prepared to do that.
So I guess that would be my concern is when is the court going to be prepared to make that determination?
Well, I will give you an evidentiary hearing and you can make that argument. And then I will make a ruling. And if you want to do that today, we'll do that today. It's up to you.
If I may confer with my client just briefly, Judge.
Your Honor, as far as the evidentiary hearing, while he's conferring with his client on what he's going to happen with that, I'm going to respectfully say that any evidentiary hearing on that topic, I would ask to be continued to another date for many reasons, one of which I just got on the case, as the court all knows, and we've already said on ad nauseum here this morning. Secondly, there are things that are related to what is happening with Mr. Thomas in his own personal life that I need to get proof of.
Mr. Bellamy, I'm going to, Mr. Kirby is right. He's new to the case, and I think under the circumstances, this is a unique situation. I'm of the opinion that we said, I can give you July 22nd.
Give me one moment, Your Honor, let me check. I have a preview of the scheduled final hearing on July 22nd.
All right, well, my calendar in the month of July is full, but many of those are criminal trials. I've missed a call from General Lee Willoughby over in Cheatham County because I'd asked him about, are any of those, all of us who practice law know that just because it's on my calendar doesn't mean it's going to go. So bear with me and let me step off. I have a TBI agent that was supposed to be here. All right, he's here. And I need to see him about a judicial subpoena. Then I will check with Mr. Willoughby about that calendar, and then I'll let you know what we have available. My inclination is to set it for July, after you get Mr. Kirby an opportunity to be heard, or rather get prepared, and then we'll come back. So,
Understood. Thank you.
Thank you.
A DNA test proved he was the father, and the judge made a shocking ruling. The court would keep jurisdiction over the newborn despite the interstate adoption battle. But in a dramatic twist, the judge refused to immediately give the baby to the father, setting up an explosive custody fight that is far from over. Let us know in the comments, and don't forget to like, subscribe, and turn on notifications for more shocking courtroom moments.